I want to say thanks for coming. It's an interesting day, of course, June 6th. I've been out of the clinical arena, so to speak, for 7-8 months. And had someone told me 3 or 4 years ago that this is what my life would look like, I probably would have scoffed at them and said they're watching too many Dre B movies. But here we are. I've got attorneys to my right and my left, and they're going to talk about the legal aspects of filing 2 suits, which have indeed been filed today. We filed 1 suit in the federal district court against the Minnesota Board of Medical Practice, and we filed another suit against Keith Ellison, the Attorney General, in the Minnesota State District Court. And again, I'll let the attorneys deal with the specifics. I do want to make just a couple of comments. This is about a lot more than just a family doctor in Carver County who happened to be serving in the Senate during a time when a pandemic hit that nobody could have ever foreseen. I really think that this has a tremendous amount of impact on physicians and on patients and ultimately on every one of us. In medical school, one of my earliest heroes was a physician who had, by the time I got in medical school, been dead more than 100 years. And his name was Dr. Ignaz Semmelweis. And he was the one, he died the same year Abraham Lincoln did. And he was the one who came out and said, physicians are causing postpartum women to die at 3 times the rate of patients who are cared for by midwives. To go back and unpack that just a little bit, Semmelweis was saying that when physicians were going from one sick patient to another without washing their hands with, if you will, antiseptic solutions, that they were spreading the disease. The midwives were doing it differently, and their postpartum death rate was 1/3. As you can imagine, for being the skeptic that Semmelweis was. He was ridiculed, he was ostracized by many of his peers. I can't help but think that that's what's going on during the pandemic at some level. If you dared to challenge the narrative that was out there, you were fair game. That's why we're here today. I think that physicians have had a chilling effect on their ability to have candid conversations with patients. And because of that, I think patients have felt betrayed and abandoned. Patients have been dismissed, not because they came into the doctor's office demanding a given prescription or medication, but they did demand to have the conversation. And for that, many of them were dismissed. I think the quality and the breadth of our informed consent has been truncated. I think physicians, as the Washington court 2 weeks ago came out, have had a chilling effect on free speech. There was a decision in the Washington State Court of Appeals, Division 111. And in the opinion it said, public dialogue by a profession receives the greatest First Amendment protection. And it goes on to comment about the chilling effect upon the exercise of First Amendment rights that you'll have on professionals. We've got to be able to talk to our patients candidly and honestly, and I don't think that's happening. It was interesting to me today that there was an article in Medical Economics, which is a major medical journal, and it was a physician author who takes on the issue of physician moral injury. And people have asked me, Scott, do you feel like you're standing alone? Do you feel like the medical profession has not been there standing at your side? And I'll be honest, it's been a mixed bag. More and more over the last 6 to 12 months, physicians have quietly stepped forward and expressed their appreciation for what I've been doing. But Wendy Dean is a physician, and she says this about moral injury. She said, it's the sense of feeling as if you're betrayed by someone in a position of authority in a high-stakes situation. And that situation causes you to transgress your deeply held moral beliefs and expectations. And in medicine, those beliefs and expectations are the oaths that we took to put our patients first. Our patients first. I think that the pandemic and what has happened to me impacts physicians across the nation and frankly across the globe. So the first case will be about the Minnesota Board of Medical Practice in federal court. But the second case is in the state court regarding Keith Ellison, Data Practices Act. And I just wanted to highlight the fact that a couple of years ago, perhaps 3 or 4, when Keith Ellison came to me and asked me if I would serve on the task force on lowering pharmaceutical drug prices, and then subsequently asked me to co-chair that body. Part of the reason he did that is because he wanted my skepticism. He wanted me to be on that task force because he knew that I would stand up. A little more than 2 years ago, less than a mile away from me, Attorney General Keith Ellison came out to Chancellor, and the two of us co-sponsored, co-hosted the town hall asking people, what do you think about Big Pharma and the cost of medicines and what you're paying? In this report, which received applause from across the country, Keith Ellison said, the 15 people who served on the task force brought a great diversity of experience, knowledge, and perspective. I thank each one of them, especially co-chairs Nicole Smith-Holt and Senator Scott Jensen. This thorough, eye-opening report answers the overall question of why the pharmaceutical drug market doesn't work. Goes on to say this isn't the end of the task force work, it's the beginning. He talks about diabetic insulin costs doubling between 2012 and 2016. He talks about the misuse and the abuse of federal patent and exclusivity laws by drug manufacturers. And I have to remind you, this report was done before the COVID pandemic. He talked about Crestor, a medication used to lower high cholesterol, costs up to 336% more in the United States than it does in Canada. He went on to speak of a variety of issues. He said Congress should continue to study means to combat drug manufacturers' abuse of patent laws. He talked about terminating all FDA exclusivities for a drug if the manufacturer engaged in certain wrongful acts, including misbranding, illegally marketing the drug, or entering into an anti-competitive settlement of a patent lawsuit. So I'm just going to close my comments by saying this. Have I dared over the last 3.5 years to challenge the value of lockdowns? I have. Have I dared to challenge the efficacy of vaccines? Yes, I have. Did I challenge the validity of the models that came out? I did. Did I challenge the horror of closed schools and what it did to kids? I did. And did I challenge the value of hasty research? I did. I challenged Big Pharma and Big Tech and Big Government. I challenged the fact that there was an odd mixture of agendas on their behalf. I think because of that, I have been treated in a singularly horrific manner. That's why we're bringing this to court. This is about the First Amendment. It's about the 14th Amendment. And on a personal level, it's certainly about the fact that I want this to stop. I've had 6 investigations. Not one of them that I'm aware of involved a patient who received a healthcare service from me. Not one of them represented that critical nexus between a physician and a patient. I believe the Minnesota Board of Medical Practice was weaponized by activists. And I think it cost me dear from a reputational standpoint, potentially impacting somewhat on the governor's race. We'll never know that. In the end, I think it was about bullying. I think it was about our Constitution being pushed aside. I think it was about if you dare to disagree, you're in trouble. And I think in the end, we saw emergency powers grow government like we've never seen before in our lifetimes. And in the final analysis, I stand before you today because this has got to be about freedom to truly exercise our First Amendment rights. And I'm going to ask my attorneys if they would go into more depth in terms of the suits themselves. Greg, would you start? Thanks.
Sure.
Greg Joseph.
Sorry, I've got a little allergy thing going on, maybe the smoke, so I apologize. If you care about the Constitution, if you care about the Bill of Rights, and you care about the First Amendment, you should be outraged at what was done to my client over a nearly 3-year period by the Board of Medical Practice and its members. This isn't about politics, this is about speech. And just because my client's a licensed physician in Minnesota doesn't mean that a government board gets to regulate what he says in a public forum. And that's exactly what happened for nearly 3 years, over 6 investigations. And we're not going to stand for it. It's that simple. The board had no jurisdiction over any of these complaints that were fielded by members of the public. We don't know where they came from. There was a severe shortage of due process afforded to my client. And these were deliberately used by the board to chill his speech and to retaliate against him for challenging the official narrative related to COVID-19. These are not complicated lawsuits. It's clear what was done. He was investigated on the basis of speech alone and not on the basis of the practice of medicine. We could have named more names in the lawsuit. You'll notice there were 2 courts filed. I'm going to let my colleague James Dickey speak about the state suit, the data practices suit against Keith Ellison. We anticipate that the federal suit could well be amended once we receive more information. But that's where we are now, and we look forward to justice. This is about righting a wrong, and that's what we're pursuing.
Greg, can you give us your last name?
Greg Joseph.
Common spelling?
Common spelling.
And Greg with 1 G?
Greg with 1 G. At the beginning and end.
Yeah.
Yeah. James.
Thanks. I'm James Dickey from the Upper Midwest Law Center, and we're grateful and an honor to be here representing Dr. Jensen along with Greg Joseph in the federal lawsuit. And we're also going to be representing Dr. Jensen along with Greg Joseph in a state court lawsuit related to Attorney General Keith Ellison and his office's failure to turn over certain data that we requested as part of an April 20th data request. And so essentially what happened was while we were considering all the different things that have happened to Dr. Jensen over the last few years, we made public data requests to different agencies, including the Attorney General's office. And in response to that, the Attorney General turned over some information, but there was some information that the AG said was withheld. I followed up to find out exactly what that information was and what the justification for that was. And the responses we got were underwhelming to say the least, including a response that said that some information was being withheld because of the concern that Dr. Jensen might talk about it publicly and that might have a negative effect on the office. That's not a proper use of the Data Practices Act's exceptions to disclosure, and so we believe that this action not only violated Dr. Jensen's rights under the Data Practices Act, but also violated his First and 14th Amendment rights, because members of the news media and others would certainly be provided that sort of information, and yet Dr. Jensen, for wanting to speak publicly as the news media does, was not provided that information. So in short, what we're seeking is the compelled disclosure of that information from the Attorney General's office, and in addition to that, any fees and costs that go along with the lawsuit itself. So with that, I can turn it back.
For either one of you, can I please do time for questions? As you talked about the nexus between the patient and the doctor, none of these complaints seem to be involving that, the involved opinions that he espoused publicly. Is that accurate?
Correct. And that's not coming from us. That's coming from the Board of Medical Practice. These were public complaints about Facebook posts, about videos, about comments to the press, about newspaper articles, about radio and TV interviews, about speeches on the campaign trail. That's what this is about. Not patient treatment, not medical practice.
And on top of that as well, the Board of Medical Practice does not have to go through what they did with Dr. Jensen and demand that he provide responses under threat of penalties. They can dismiss complaints that on their face appear not to be within the board's jurisdiction, and complaints that have only to do with political speech are not within the board's jurisdiction.
And do you not have any information? Do they not tell you who it is that initiated these complaints?
We're given, Dr. Jensen was given a list of summary allegations. So we don't know who the complainant was. All we have is a basic summary, and he has no due process rights.
And are those all lined in the court filing?
They are.
If you look at my response, I believe, to the 5th investigation, I specifically advised the Minnesota Board of Medical Practice that this has gone beyond ridiculous, and I asked for the identity of the complainants, the people who put forward the allegations, and that was not allowed. At that time, I also asked for a public hearing, or a public meeting, instead of it being private. I asked for it to be live streamed so that people could participate in what's happening. I remember when I sat in the Senate, Tom, I remember the value of knowing that you can get data as the media or anyone else through our FOIA laws federally or the data practices in Minnesota. But I remember in November of 2021, I believe, where the Department of Health had forward and disclosed emails and messages. And what we found was there was a specific concerted effort to see, would there be a way to sort of spin the spread of disease in the nursing homes and put the blame somewhere else. And they even talked about parents of kids who were participating in extracurricular. Can you imagine if we hadn't had the Data Practices Act, if we didn't have them forced by law to give us that information. That would never have come out. That's all we're asking. We simply said, if it says Scott Jensen on it, or it's about Scott Jensen, we want to see it. And the idea that I'm being told, no, you can't see it because if we give it to you, you might talk about it publicly, is the absolute reason why those things are in place. This is America.
James, stop just for a second. I don't know if these people want to get through and they don't want to be.
Oh, sure.
Yeah, James.
If you guys want to go
do
through,
you have a copy?
You can. We'll
was
turn
that
the
said
camera
in
off for
the
a second.
email about?
I don't want you to stand in the parking
they
lot.
can't
all
give you
day.
the data because was
Let's
that in
no,
an email? And
we
can you
do
share
too,
that
so.
if so?
So there's a letter from the Attorney General's office sent to our office
Yeah.
as representatives for Dr. Jensen, saying that there's a small subset of data that, essentially we believe that if Dr. Jensen were to talk about it publicly, could cause harassment to our employees and that kind of thing. But we don't know how large that set of data is. We don't know what the individual employees in the AG's office were saying. We don't know which employees those are. And those people all could conceivably be part of the investigations that Dr. Jensen's been dealing with over the last 3.5 years, which is why that information, it can't just sit behind some wall based on the subjective interpretation of that law by the AG.
Okay. Yeah. Go ahead,
I
Tom.
missed the question, well-directed traffic. Is there, why the two different lawsuits? Why not both of them named in the same suit? Can you explain that?
Sure. Yeah. Right. Well, the primary reason for that is because the data was withheld. We did a Data Practices Act to gain that data to determine exactly what the role of the Attorney General was in this free speech violation, and the data was withheld from us.
Right, and so on top of that, usually when you bring a federal lawsuit, federal court wants to exercise jurisdiction over the claims and issues that arise out of the same nucleus of facts. So we felt like the investigations themselves are one issue, but this data issue came after that, and is following up after the initial investigation.
So the Ellison lawsuit is about the withholding of public data or
Yes.
data that you should have had access to.
Correct.
And then the Board of Medical Practices is about what you believe to be targeting you, not to do with your actual medical practice.
Yes, I think what we're asking the courts to do is we're saying, we want you to help draw a precise line for the Department of the Minnesota Board as well as Minnesota statutes. Where is that line between free public speech and professional conduct as it relates to the practice of medicine? Because if I get up on the Senate floor and make a comment, as a senator, it seems astonishing to me that I might see my medical license questioned. Perhaps I was talking about the value of eggs lowering or elevating cholesterol, the value of an aspirin tablet a day, whatever, if that came up. The fact that there was no relationship with me when I'm making that comment with patients. And I think the NIFLA case that Mr. Greg Joseph could comment on, we do highlight that in our brief, but that specifically calls for some sort of connection between the doctor and the patient as a patient-doctor relationship. And if there isn't that nexus there, then I get to have free speech, and that was denied.
Any second thoughts about any of the things that you said during the pandemic, or do you still believe to this day that you were correct in questioning the lockdowns and the vaccines and those types of things?
It's a fair question, Tom. Looking through the retrospective scope, hindsight's always 20/20. I can think of a couple of things right off the bat. First off, I probably should have done a better job of providing a disclaimer at the beginning of every speech I made. I should have probably just said, okay, listen, I'm a senator or I'm running for governor. I don't have a relationship with my audience. I'm not speaking to a group of patients. Here's what I think. Maybe that would have provided the board some comfort. I think that there were things I ended up being wrong on. I remember thinking initially that the COVID-19 virus probably did come from a spontaneous reassortment of RNA in, if you will, nature. And I think when Robert Redfield left the CDC and came out 3 months later and said that he no longer thinks that this was necessarily something that happened in the wet market and that this may well have come out of a lab, that made me rethink it. I think right now the balance of data would probably say that this was not a spontaneous reassortment. So I got some things wrong, I got some things right. You asked about lockdowns. I think I was absolutely correct in questioning the value of those. You asked me about vaccines. I was absolutely correct in asking, Are they going to keep you from getting the disease? Are they going to stop you from transmitting the disease? I think the facts bear that out. I think the majority of Americans would say, yes, Jensen was not wrong on the vaccines, that they weren't, if you will, delivering what we've been told they deliver.
Have you been able to get data on how many other physicians have been targeted, like, maybe not like him, but anybody else who's had, is it 5 or 6 complaints?
There have been 6 investigations.
Have you been able to get any data that indicates, oh, here's a list of other doctors who face 6 complaints?
Part of the reason this is such a serious thing is because we can't. It's impossible to know how many people didn't speak out because they were afraid of action that would be taken against their license. So no, we don't. It's very hard to quantify that.
So you don't, is there no repository of, here's the number of complaints filed against doctors in Minnesota that you've been able to get access to?
Right now, that's probably a we don't know what we don't know question. So once this case begins and once we get to discovery, I think we'll get some answers.
Yeah, Greg, what exactly are you all seeking in the federal suit for damages? You know, you said in the state suit to compel the data disclosure. What's the goal of this one?
Well, you know, because we filed under 1983, they were seeking nominal damages, we're seeking compensatory damages, we're seeking punitive damages. These were acts that were undertaken by people in the name, under the color of state law. Okay, so in an amount to be determined later, we'll have to figure out what this actually means once we get into litigation.
So no sort of public apology or anything like that, or?
Courts aren't great at ordering people to make public apologies, but it'd be nice. We certainly deserve several.
And this is the federal lawsuit against the Board of Medical Complaints.
And its members.
And against Ellison again, is it more just attorney fees? And what did you say you're seeking there?
It is to compel the data to ensure that the Attorney General doesn't have the same bad practices on an ongoing basis, so injunctive relief there. And it's also attorney's fees, which under the MGDPA, the Data Practices Act, are recoverable if the court decides to award them. And in addition to that, we do have claims under the First and 14th Amendments in that case in state court because that data was withheld for the reason that Dr. Jensen might speak about it publicly on matters of public concern.
Any sort of precedent in Minnesota or elsewhere for this type of action against a board that regulates doctors?
There are a couple. Scott mentioned the NIFLA case, and there's one other one too, but really what he mentioned, this line between speech and professional conduct, has really not been drawn with any kind of precision. So there have been some cases, but none that really put a fine point on it the way we're trying.
Scott, you suggested the medical board investigations at the start of your remarks. You know, you don't know what impact that might have had on the governor's race. Do you think the comments you made, though, the comments themselves, do you think that could have had an impact as well, or?
It's impossible to know, but I do think that when you're in the last month of a campaign, where polling data shows different results, and some polls indicate that it's very close, and I think there was one that actually had us a half a point ahead, and you have the governor of Minnesota highlighting the fact that I've been investigated 5 times, and what could that say about me as a candidate? I think that's problematic. I think it's quite interesting that generally the Board of Medical Practice expects to open and close an investigation within a few months. My first 3 investigations were closed easily within 2 or 3 months. I think it was the 3rd investigation where I wasn't even given a chance to formally respond. I was simply sent a letter saying, oh, by the way, we had another set of allegations came forward, we dismissed them. So to me, the board sort of at that point in time said, we do have the discretion to dismiss. But then along comes another investigation. So I did another response, and then that was dismissed. But it was the 5th investigation that started in, I believe, October of 2021. And I responded in November. And then in December, there was a response from the board for more information and patient charts. I gave that and delivered it, I believe, on January 12, 2022. Now, all the other investigations have been wrapped up within a couple, 3 months. But that 5th investigation, I turned over data to them in January, and I got crickets. There was nothing. That sat there from the Minnesota Board of Medical Practices perspective for 12 months during the entire campaign. During the summer of 2022, I reached out to the Board of Medical Practice saying, could you help me understand what is the standard of care expected of a physician in regards to prescribing medications off-label? I was told the board does not participate in creating or developing standard of care. But by damn George, if you do it and a complaint comes in, we'll investigate you. I felt like as just a common family doctor trying to do his job, I felt like I couldn't win. Every which way. I asked for help. They said, we're not giving it. But by the way, if a complaint comes in, and oh, this other one is overlying for another 7 months, now we're just going to keep that hanging out there. And I think that perhaps your question, Ryan, really gets at the point. Do I think it was determinant in the outcome of the election? No, I don't. I don't think you lose by as many votes as I lost by and say, you know, I'm going to cry sour grapes. But do I think it impacted on the way we campaigned? Did it impact on the decisions that people made? Did it perhaps provide one candidate with a comfort level that I probably don't need to be out in the public eye as much because I can always just throw these bombs out periodically? Who knows?
Is that the only time you appeared before the board, where you physically went in? And had you posted a video, I think, in February about how you had it dismissed again? I think both you and Greg were there. Is that the only time you actually appeared before the board?
Yes, yeah, that was in March of 2023, about 2 months ago, 2.5 months. And so it was in January of 23, 2 months after the election was over. I got a letter from the Board of Medical Practice, but this time it was the Attorney General's office that was reaching out and saying, these are the rules, this is what's going to happen, you're going to appear before us, your response is not adequate to dismiss the allegations. And that was the first time that Keith Ellison noticeably got involved with me. But there is Minnesota state statute that compels the Minnesota Board of Medical Practice to recognize that the Attorney General does have some intersecting responsibilities with the Board of Medical Practice. And that's partly what we'd like to know about in this data practices request is what was the Attorney General's office doing along the way, because we think we're entitled to know.
Is it your belief that they prolonged this, they did not exonerate you during the campaign because, as you claim, you think it was weaponized, that they didn't want you to be able to say, look, I've been cleared again during the campaign?
It is my question. I don't have a belief because I want more information.
Could I add one thing too? The conference in March you're referring to, all the previous complaints had been dismissed. Okay, all of the complaints that began in June of 2020, July of 2020 had been dismissed. The conference that was called this year revived all of those prior complaints and then added as many as 5 new complaints, which apparently had already been investigated without any notice of any kind to my God. So he had already addressed all the complaints that had been dismissed, and now they were being brought to bear against him.
And I'm not sure what they said in that conference, but even though there wasn't that nexus between doctor and patient, did they make the case that because you're a respected public official and you were saying these things that were counter to what the federal government, the CDC, and others were saying, that maybe had almost the same impact on potential patients, maybe not only of yours, but of others?
I don't think the Board of Medical Practice, and I have to be careful because that was a private confidential proceedings, what they shared with me. I don't think they were saying it was equal, but I think that their concern was that it was impactful, that if I made those comments, that might impact on patient behaviors and things like that, even though I did not have a relationship with those folks.
And you don't believe that is true?
I didn't say that, Tom. I think that free speech does have impacts that you can't assess or necessarily anticipate. But I think when you're talking about free speech, as I mentioned earlier, there's a chilling effect if you're going to say, Scott, you don't get to say that because you might impact someone. Without that patient-doctor relationship, and particularly in the role as a public servant and as a candidate for governor, I have to have free speech, or we're making a mockery of our democracy.
Briefly, and I want to address the question you just asked too. The federal courts are clear that there is no separate category for professional speech. Okay, so just because he has medical license doesn't mean that he's restricted as to what he can speak on. Very clear.
Even if there might be a public health concern about it?
Right, correct. It's still speech and it's not professional.
And the March 2023 conference, was that related to the 5th, the 6th investigation? I know the 5th sat there open for a year, or was it the new one?
It was, well, the 5th investigation was opened in late 2021. In early 2022, they requested additional information from him after his initial written response, under threat of further sanctions if he didn't respond. Then after January of 2022, it sat there with no activity of any kind hanging over his head during the entirety of the campaign until January of this year, when it was revived and then he was asked to come. So we didn't know the details of the notice of the conference until January of this year.
So Ryan, if you just go back to January of 2022, I turned over de-identified patient charts. I provided further supplemental response, and then everything went dark for 12 months. But then in January of 23, it was difficult for me to recognize exactly what they were saying, because as Mr. Joseph identified, all the allegations seemed to be resurrected in the January letter, but there were new ones I hadn't seen. For instance, some of the charting that had been submitted by me to the board didn't have, evidently, the quality of handwriting that they wanted. And no, it's not necessarily a prerequisite to get into medical school to have bad handwriting, but I do qualify. I have bad handwriting. But that was brought up in January of 23, 2 months after the election, after this investigation had been going on for 14 or 15 months, totally out of the blue. I had no idea at all. And it was my handwriting that was.
And that was a formal complaint
That
about
was
your
on the letter from Keith Ellison.
Okay.
That was addressed at the conference in person.
Okay.
So just to be clear, is there 5 or 6 complaints that you filed?
There were 5.
5.
But then the 6th one was really the January letter, because that letter brought forward almost a half dozen new allegations that had never been seen before. So that would have
Also, not the original 5. There was a whole additional.
There was a whole other set of 4 or 5 new ones, along with resurrecting numerous ones from the old one. And if you actually count the allegations that come from investigations 1 through 5, it comes to something like 18 or 19.
And you don't know who they came from or where they come from.
Not at all.
And the Board of Medical Practices does not release that.
So, right. So let me just. So, it actually adds up to 13. Okay. The first 5 complaints add up to 13. They then added potentially 3
Because some of them
more.
they lumped together. You mean?
Some of them were lumped together in single complaints, right? They had different board file numbers, and it's explained in the complaint that you'll see. But there were actually 13 total. Then with the last notice, it looks like they added 3 more. So we had potentially as many as 16, but he was accused of 18 separate violations. So there's at least 2 that were investigated, apparently, at some point. We don't even know what they are.
And all of them were dismissed.
Yes.
All of them were
Every-
dismissed.
every-
Correct.
And that's interesting too, Tom, that you asked that, because not only were they dismissed, it said in the letter, case is closed. Now, previously allegations had been dismissed, but then they had been raised back up in this January letter from the Attorney General that this would be part of the conference. So I had thought that investigations 1, 2, 3, 4, and 5, 1, 2, 3, 4, had been handled and done. But some of those allegations had found their way into the final letter that called for a personal in-face confrontation.
One additional thing, and you'll see this in the complaint as well, but I wanted to point out that Investigation 4 had to do specifically with petitioning the government for redress grievances. Right there in the First Amendment, Scott was investigated for putting his name on a lawsuit.
Actually, I hadn't put my name on the lawsuit. I put my name on an affidavit.
Yeah.
And
It was part of a lawsuit.
You were
Yeah,
originally
that was-
a named plaintiff and then removed, right?
Exactly, yeah.
Will you be able to email us these?
Ray, could you
complaints?
comment for the media here, as well as Facebook, where people can get a chance to read through this and chew on it and think about it? Where do they go?
I think we're gonna post this right shortly. We'll have it posted
On Facebook?
Because sometimes it takes them a while to get it posted for us to look at.
We're hoping there will be a judicial assignment this afternoon sometime, so we'll get it up.
Yeah, there should be a federal court judicial assignment this afternoon. It'll be available. It's already available on Pacer for the federal court complaint. State court complaint was also filed earlier, so when the Carver County courts accept the complaint, it'll be ready. But there also will probably be a press advisory going out with copies of everything too.
And would that be this afternoon?
Yeah. Oh yeah. I
Okay.
think if it's not already something that may already be. From our office, we have at least one press release. That's been
That would be helpful.
Are you sharing a
Definitely.
copy of
I
that
can give
letter
you a-
from the AG too,
Yeah.
where they say we're not going to give this to you because you'll talk about it,
Yep.
basically?
Yep.
Okay.
And of course, I'm paraphrasing. You'll see the actual.
No,
language.
yes, I know.
And that'll all be in what you're releasing today.
So the state court complaint includes the complaint itself, and the exhibits are all just the letters back and forth between my office and the Attorney General about the data request. And the federal court complaint has attached to it all the different complaints and response, not all the responses, all the.
And you still don't have the data that you wanted from Ellison, right?
No, we don't.
We still
That's
don't have it.
so at the end of you'll see at the end of the Attorney General's office's letter, it says they go through the reasons why they're not going to provide all this data. They didn't respond to some of the asked requests for clarification that I had. Trying to avoid a lawsuit. That's the point of talking about it. And at the end it said we consider this matter closed.
Yeah.
Well, it's not closed anymore.
Okay. Great. Okay, we'll look for that. So it should be